Welcome, everybody. Welcome to this episode of the Law of Self-Defense. I am, of course, attorney Andrew Branca for Law of Self-Defense. Come on in, make yourselves welcome. Let me take a quick look to make sure we're streaming in all the places that we need to be streaming. And YouTube looks good. Law of Self-Defense member page, the only place where we accept comments or questions, is looking good. The Rumble page is always delayed. And taking a look at Twitter, which has had me locked in at 69,500 followers for months. 4 months. I'm sure it's just a coincidence. I'm sure it's nothing deliberate by the algorithm. I'm sure it'll all work out just fine. All right. Well, looks like we're streaming everywhere. So today's show is about the use of force in self-defense in the context of highly defensible property. It's a topic we talk about on a regular basis, but we have a couple of, the cases themselves aren't that complicated. We have a North Carolina woman who shot a car invader. We have an Arizona man who shot a home invader. And the facts of these shootings are pretty straightforward. But what they do is give us an interesting opportunity to look at the use of force in defense, self-defense, in the context of highly defensible property under three different legal paradigms. Because the way North Carolina treats defense of highly defensible property is, in important ways, different than how Arizona does it, and different than how we do it here in Colorado. So we will be using North Carolina, Arizona, and Colorado to illustrate the actual law of self-defense, use of force in defense of highly defensible property under those three different legal paradigms, which fairly represent the options that are available across the country. So with that out of the way, let's go ahead and start the formal launch of today's show. Here we go. All right, folks, and before we jump into the formal start of the show, I do want to mention, of course, the sponsor of today's Law of Self-Defense show is none other than Law of Self-Defense itself. I guess that wasn't a great idea. Let me see if I can fix that. You can get a copy of our best-selling book, Law of Self-Defense Principles, for free from us. Now, I urge you to check it out on Amazon. You'll see it's 5-star rated on Amazon, but don't buy it on Amazon. They'll charge you $25 for the book plus shipping and handling. We'll give you the book for free. We only ask that you cover the cost of shipping the book to you. So we do ask that you cover the shipping and handling, but the $25 book is free if you get it through us at lawofselfdefense.com/free book. Real physical book, folks. This is it. Not just some PDF download. Makes a great gift if you already have a copy of your own at lawofselfdefense.com/free book. All right. So I have a couple of news stories here. The first one involves a North Carolina woman who shoots a car invader. Let me share this with all of you here. This happened last week. A legally armed woman in North Carolina acted in self-defense when she fatally shot a man during a road rage incident at a grocery store parking lot, according to the local district attorney. Quoting now the district attorney, quote, "I think what's really important here for people to understand is that provision in our law is not an invitation to vigilante justice, but it does allow, when someone has a responsible fear, I think they mean reasonable fear, for imminent death or bodily injury, that you're allowed to protect yourself." Wake County District Attorney Lauren Freeman told the news media. Actually, of course, the requirements for self-defense in the North Carolina law are a little more complicated than that. You need the 5 elements of self-defense, absent the element of avoidance. By the way, this 5 elements of self-defense cheat sheet is also something we make available for free. It lists the 5 required elements for self-defense, up to 5. Not every state requires all 5. If you don't understand these 5 elements, folks, you just can't understand self-defense law at all. So if you do nothing else, I would urge you to get this free 5 elements of self-defense PDF download. You can get it at lawofselfdefense.com/elements. It doesn't cost a penny. And for those of you who might be firearms or self-defense instructors, we also have this available in a poster size. If you'd like something to hang in your classroom, that's not free. The poster's not free, but you can learn more about that too at lawofselfdefense.com/elements. But obviously, the DA here is just speaking to the news media, which probably can't understand what he's saying anyway. So even if he got it right, they would probably report it wrong. But continuing with the event, Stephen McLam, 49, and he'll never get a day older, was fatally shot outside a Food Lion located at the Greystone Village Shopping Center in Raleigh last Tuesday after 5 p.m. Authorities who reviewed the footage of the scene say McLam was the aggressor in the altercation, who tried to pry open the woman's car door before she fired at him. Quoting now the district attorney, Mr. McLam was the aggressor. He followed the other individual, the woman shooter, into the parking lot, and upon getting out of his car, approached her car and attempted to get into her car. She, acting in self-defense, shot and killed him. Let's see. The altercation began as a road rage incident, according to local media reports. Freeman, the DA, said law enforcement officers were able to review various footage of the scene and interview witnesses amid the investigation. We were fortunate to have access to various video. Also, there were witnesses in the area that were able to give a pretty clear image as to what happened here. The woman, who has not been identified, legally owns the firearm and has no prior criminal history. Under North Carolina law, individuals are permitted to use force to protect themselves when there is a reasonable fear of imminent death or serious bodily harm. Well, that's certainly one of the requirements. That's a necessary requirement, and it's not by itself a sufficient requirement, but that's fine. We'll take that as a abbreviated summary. McLam was taken to a local hospital after the shooting, but he died from his injuries. Yeah, don't try to get into other people's cars, folks. The person inside the car may be a woman with a gun who's willing to use it to shoot you lawfully to death. So let's take a look at the law around this. Now, this is, of course, a shooting in self-defense, but it's a certain flavor of shooting in self-defense. It's a shooting of self-defense in the context of highly defensible property. Now, at Law of Self-Defense, we teach that there's two categories of property: mere personal property and highly defensible property, two different buckets. Mere personal property in 49 states, including North Carolina, can only be defended with non-deadly force. Now, we're talking defense of mere personal property in the absence of a threat to persons, right? Because if there's also a threat to persons, if it's a robbery type of event, a theft of property with threat of harm to the person lawfully possessing the property, give me your wallet with a pointed gun. That's not really a defense of the wallet scenario, right? That's really a defense of the person scenario. But if we're talking purely a threat to personal property, only non-deadly force can be used to protect that property, and only sometimes, not under every circumstance. Sometimes no force is allowed. Now, I said 49 states, including North Carolina. There is one state, Texas, that does have provision for the use of deadly force in defense of mere personal property. It has a lot of conditions, a lot of hoops that have to be jumped through, and if you miss any of them, or the jury believes you missed any of them, you don't have the justification, and if you've killed someone over that piece of property, off to prison you go for the rest of your life. So I would urge people, even in Texas, not to be killing others over mere personal property, but Texas, to be comprehensive, does have legal provision for doing that. If you'd like to see that Texas statute, it's Penal Code 9.42, and you can find it at lawofselfdefense.com/942. But certainly in North Carolina, you can only use non-deadly force in defense of mere personal property. But there's another category of property, highly defensible property. And highly defensible property is property that tends to have as a core function the shelter and protection of people within the property. And it always includes a home. So your home is highly defensible property. It sometimes, depending on the state, includes a place of business, maybe only your business, sometimes any business you happen to be in. It sometimes includes occupied vehicles. Now, unoccupied vehicles are always merely personal property. But an occupied vehicle has people inside it. So now that vehicle is serving as a function, the shelter and protection of the people inside the vehicle. So the vehicle hasn't changed, but the use of the vehicle, the nature of the use of the vehicle has changed if it's occupied versus unoccupied. And what qualifies as highly defensible property varies by state. So not every state includes all three of those: home, business, and vehicle. Many do. Some only include a couple. Some only include your home. So we'll take a look at North Carolina and Arizona specifically. By the way, for any of you who we're talking about state-specific law here, let me see if I have something I can show you on this point. Real quick. It looks like I don't. Let me see. Well, that's a shame. I'll create one real quick. So we do here at Law of Self-Defense have state-specific courses for each of the 50 states. And I'll put that here as a banner. So if you'd like to know, obviously here I'll explain North Carolina and Arizona and Colorado use of force law in the context of highly defensible property. But most of you are from other states. We do have state-specific courses that include all the use of force law for each of the states, depending on which one you order. You can learn more about that at lawofselfdefense.com/state if you'd like the state-specific use of force law for your state. So, highly defensible property. We'll look at it in the context of North Carolina, Arizona, Colorado. Always includes your home, sometimes home and business, sometimes occupied vehicle, not unoccupied vehicle. And what the states that provide additional privilege for the use of deadly force in the context of highly defensible property do typically is create a legal presumption of a reasonable fear of an imminent threat of unlawful deadly force harm by the defender inside the highly defensible property against the person threatening in the context of that property. And that legal presumption essentially gives you everything you need, presumes to be present, all the elements required for the lawful use of deadly defensive force. So what are the things that are required? Well, they're the 5 elements of self-defense. Again, you can get this cheat sheet for free at lawofselfdefense.com/elements. But the elements are innocence, imminence, proportionality, avoidance, and reasonableness. Innocence, you're not the aggressor. Imminence, the threat's actually occurring or immediately about to occur. Proportionality, you're not using deadly force unless you're facing a deadly force threat. Avoidance has to do with whether or not there's a legal duty to retreat. And reasonableness, your perceptions, your decisions, your actions in self-defense are those of a reasonable person. You subjectively believe in the need to use force, and a reasonable and prudent person in your circumstances would share that belief. You don't have an irrational fear of what's happening. In other words, you're not imagining a threat. So innocence, imminence, proportionality, avoidance, and reasonableness. Well, what these legal presumptions do for you in the context of highly defensible property is they presume that you had a reasonable fear of imminent, unlawful, deadly force harm at the hands of this intruder. Well, that's giving you 4 of the 5 elements of self-defense right there. That the threat was imminent, that your perception of the threat was reasonable, that it was a deadly force threat, and that you're the innocent actor. I mean, you're in your home and they're invading your home. And avoidance doesn't apply because, if nothing else, even if you're not in a stand your ground state, if you're in your home, for example, the castle doctrine would apply. And if you're in something like an unoccupied vehicle, you're not escaping from within the vehicle. So if safe retreat's not practically possible, then even a legal duty to retreat would not normally apply. So the legal presumption of reasonableness basically gives you every element you need to justify your use of deadly defensive force in the context of highly defensible property if you meet the conditions of that privilege for use of force in defense of highly defensible property, and you don't trigger any of the exclusions. So there's a list of conditions, qualifications, at least one of which has to be triggered, checked off, for you to get the benefit of this legal presumption. And there are a number of exclusions typically that you need not to trigger, so you don't lose the benefit of the legal presumption. Now, I want to make clear, the legal presumption does not replace your core privilege to use force in self-defense. You always have that. So if you lose, for whatever reason, the legal presumption, the benefit of this special provision for use of force in defense of highly defensible property, you can lose that legal presumption. You still have your core privilege to claim self-defense, but you would be doing it without the benefit of the legal presumption, just to be clear. So the legal presumption should be thought of as a bonus you get on top of your normal claim of self-defense. So let's make that a little more concrete by taking a look at North Carolina law. Now, remember, in the context of the facts of this case, apparently the person shot, the gentleman shot in this case, was angry over some kind of road rage incident. He followed this woman's car into a parking lot, got out of his own vehicle, and attempted to unlawfully and forcibly enter her vehicle, at which point she shot him and killed him. So let's take a look. So here's an example of, I mentioned we have state-specific law for each of the 50 states, a separate course for each state. This is pulled from Section 9, Defense of Property, from the North Carolina specific course. Again, we have this for each of the 50 states. So if you'd like it for your state, just look at the banner below, lawofselfdefense.com/state. Will take you where you can acquire that. Now, this chapter, this section of the class covers both personal property and highly defensible property. I'm going to skip over the personal property stuff because just accept up front that you can only use non-deadly force in defense of personal property. So we're going to focus here on highly defensible property. So how does North Carolina define highly defensible property? Well, here's the title of the relevant North Carolina statute, 14-51.2, Home, Workplace, and Motor Vehicle Protection. Well, that's telling you the context right now of what qualifies as highly defensible property under North Carolina law: your home, your workplace, and motor vehicle. Now, again, I caution this is an occupied motor vehicle. An unoccupied motor vehicle is merely personal property. No special provisions for the defense of an unoccupied personal vehicle. And the title continues, presumption of fear of death or serious bodily injury. So already the title is telling us this is a legal presumption statute in the context of highly defensible property: home, workplace, and motor vehicle. And the first sentence of the relevant paragraph, which happens to be paragraph B, the lawful occupant of a home, motor vehicle, or workplace. So you need to be an occupant, not owner, occupant. So these need to be occupied. And the person who has the benefit of the legal presumption is someone who's lawfully inside, who's the lawful occupant of a home, motor vehicle, or workplace. The statute continues, is presumed to have held a reasonable fear of imminent death or serious bodily harm. What's that giving you? Reasonableness, imminence, proportionality, that the degree of threat you're facing is a deadly force threat. To himself, when using defensive force that's intended or likely to cause death, so you're using deadly defensive force, if both of the following apply. So here are two conditions that have to be met under North Carolina law for this legal presumption to be triggered. One, the person against whom the defensive force was used was in the process of unlawfully and forcefully entering, or had unlawfully and forcibly entered, a home, motor vehicle, or workplace. And then it goes on to cover a kidnapping type scenario, which we'll skip here. So the important word I want you to focus on here, the phrase, is unlawfully and forcefully entering. It's not enough that they only unlawfully entered. They have to also have forcefully entered. Why both requirements? Why is unlawful not enough? Because the legislature is concerned about something we can call the innocent intruder. The innocent intruder is someone who may be in your home unlawfully. They don't have legal privilege to be there, but they're there without malice. They're not there with evil intent. And the legislature, the North Carolina legislature, does not want to give you the benefit of this legal presumption if you shoot dead the innocent intruder. Now, what might an innocent intruder look like? It could look like a tradesman, a dishwasher repairman who's sent to the wrong home. He's told by his bosses, hey, John Smith at 3 Jones Street needs their dishwasher fixed, but they can't be home. They have important appointments. So they're going to leave the back door unlocked for you so you can get in and fix the dishwasher while they're away. And unfortunately, the repairman is given an address that's incorrect. So he goes to the address he's given, but that's not the home of Jones. That's not a home where he's been given permission to enter. But he goes to the back door, believing he's at the right address. It's unlocked. He walks in. Guess what? He's there unlawfully. But he's not there with malice. He's not there to hurt anybody. It's an innocent mistake. However, there is no innocent explanation for why he would have broken something to get into the home. So when we add that condition of forcefully, we eliminate the prospect that the intruder was innocent, was lacking malice. If they broke something to get in, we can reasonably presume that they're acting with malice. So most legal presumptions of reasonableness mirror this North Carolina approach by requiring both unlawfully and forcefully entered, because it removes the ambiguity around a potential innocent intruder. The second condition is that the person who uses defensive force, the defender inside the home, business, vehicle, knew or had reason to believe that an unlawful enforceable entry or unlawful enforceable act was occurring. Why do they require this? Because they don't want to give you the benefit of this presumption if you yourself were surprised after the fact that a forcible and unlawful entry had occurred. So you can imagine a scenario in which you come across an intruder in your home, you draw your gun, you shoot him dead, and afterwards you learn that something was broken to get in. That's not what this is intended to apply to. This is intended to apply to a situation where you knew or had reason to believe. You heard glass break in the middle of the night. That would be sufficient to create a reason to believe that an unlawful enforceable entry had occurred. But you do need to be in possession of this belief. At the time you use the force, you don't just learn of it afterwards. So under North Carolina's legal presumption, and this is pretty common across other states too that have this kind of statute, both unlawful and forcible entry are required to trigger this legal presumption, and you have to have known it at the time you used force. Then we have the exclusions, and most of these legal presumptions also include a list of exclusions. So even if you achieve, meet the conditions, you can still lose this legal presumption if one of these exclusions is also triggered. And this is a pretty common set of exclusions. One of them is the person against whom the force is used has the right to be in or is a lawful resident of the home. So it's not a co-dweller. I mean, if it is a co-dweller, then they wouldn't really be meeting the unlawfully present condition anyway, right? They do have a special provision here for domestic violence protection orders. So if you're a spouse and you've been given a protection order that you're not allowed on the premises, well, then you're not a lawful resident of the home. So you wouldn't trigger this exclusion, but you also wouldn't be unlawfully. I mean, you couldn't be lawfully present if there was a court order that you shouldn't be there. The second exclusion applies to the kidnapping scenario. It's not a kidnapping scenario where the person being removed from the home or motor vehicle or workplace is a child or grandchild or otherwise in the lawful custody or under the lawful guardianship of the person doing the removing against whom the force was used. It's not a kidnapping if the person taking the child has custody, and therefore it would exclude the legal presumption. You also don't get the benefit of the legal presumption if you're using the home, motor vehicle, or workplace for criminal purposes. So if you're using your home as a meth lab, you don't get the benefit of the legal presumption. And the final exclusion, very common, the person against whom the defensive force was used was a law enforcement officer or a bail bondsman who entered the home, motor vehicle, or workplace as part of their official duties. So very common. Oh, there's a fifth one here. This is less common. Is used, has discontinued all efforts to unlawfully and forcibly entered and has exited the home, motor vehicle, or workplace. So if they've stopped trying to get in or they've left, you no longer get the benefit of the legal presumption of reasonable fear of imminent deadly force harm. Here's another presumption that these statutes often build in as well. So what we just talked about was a legal presumption about the mental state of the defender, that the defender, it's legally presumed the defender had a reasonable fear of imminent deadly force harm. But many states also add a legal presumption about the mental state of the intruder. And here it is. A person who unlawfully and by force, both unlawful and forcible, enters or attempts to enter the home, motor vehicle, or workplace is presumed to be doing so with the intent to commit an unlawful act involving force or violence. And then they have some definitions here. Here's home, a building or conveyance of any kind to include its curtilage. Curtilage is the area immediately around your home. That's part of the normal day-to-day use of your home. Whether the building or conveyance is temporary or permanent, what would a conveyance be, by the way, folks? That would be like an RV, right? Or a trailer that you may be vacationing in, which has a roof over it, including a tent. So while you're using a tent to live in, while you're camping, the tent becomes your home for purposes of this legal presumption, as long as it's designed as temporary or permanent residence. So it's not just storage. It's a place where people would live. Motor vehicle is defined elsewhere. Workplace, a building or conveyance of any kind, whether temporary or permanent. So a food stamp would work. Mobile or immobile, has a roof, including a tent, which is being used for commercial purposes. And then a definition of curtilage. I don't want to dive too deep into that. And then we get to jury instructions, but I'll skip that as well. So the important points for North Carolina is that I want to focus on in today's show is this requirement that the intrusion be unlawful and forceful. So both unlawful and forcible to remove the risk of the innocent intruder. Now, let me take a look at the next news story I wanted to share. This one is out of Phoenix. Let's see, how do I stop the slide? And go to the next news story, which is very, very short. So this is out of Phoenix. A Phoenix homeowner shot a man. This is just yesterday, folks. A Phoenix homeowner shot a man accused of breaking into his home early Thursday morning. The city's police department said officers were called to a home shortly before 1 a.m. where they found a man suffering from a serious but non-life-threatening gunshot wound. Investigators learned that he was shot after he entered into the house of the victim. Authorities said they believed the shooting was self-defense and did not arrest the homeowner. So neither the woman who was involved in the North Carolina car invasion shooting was arrested, and this homeowner was not arrested. This is pretty common not to be arrested in these highly defensible property scenarios, folks, because it's so obvious that the fight came to you if you're dealing with an intruder into highly defensible property. That's very different than if these shootings had just happened out in a public street. Then you should absolutely expect arrest. And I would expect arrest even in the context of highly defensible property, but it's more common there that you'll see a non-arrest by the police of the shooter. So pretty straightforward facts here, right? Nothing very complicated. Phoenix homeowner, dude tries to break into his house at 1 a.m. and he shoots the person trying to break into his house. Apparently not very well because the person trying to break in survived. But nevertheless, there we are. Pretty straightforward facts. So let's take a look at how Arizona treats defensive property. And again, I'll skip over the defense of personal property. This, again, is a state-specific course of instruction. This one for Arizona, of course. And Arizona applies their highly defensible property legal presumption to residential structures and occupied vehicles. And just like North Carolina, it creates a legal presumption that the defender had a reasonable fear of deadly force from the intruder, imminent deadly force, and a second presumption about the state of mind of the intruder, that the intruder intends deadly harm. So this is personal property. Let's skip over that. Let's get to, let's see. So Arizona is a little weird here. So first, they kind of discuss the use of force in defense of premises in one statute, 13-407. And really, in this statute, they don't give you anything special. In fact, the conditions that have to be met here to privilege the use of deadly force in defense of premises under 13-407 are the same conditions you need simply for deadly force self-defense, without the benefit of premises. So you're not really getting anything extra here. Don't worry, Arizona does give you extra privilege to use deadly force in the context of highly defensible property, but they do it a bit later in a different statute. But just for purposes of completeness, we can see here 13-407, justification, use of physical force in defense of premises. You're justified in threatening to use deadly force. So not using it, but threatening to use it, or threatening or using physical force, by which they mean non-deadly force, against another to prevent or terminate the commission or attempted commission of a criminal trespass. So not just a simple trespass, a trespass intended for criminal purposes. So you can threaten deadly force or threaten or use non-deadly force to prevent or terminate the commission or attempted commission of a criminal trespass. But you can't use deadly physical force except in defense of yourself or another person, as under the normal self-defense and defense of others laws. So you'd have to meet the normal 5 conditions of self-defense. Then there's a definition of premises: any real property, any structure, movable or immovable, permanent or temporary, adapted for both human residence and lodging, whether occupied or not. So then we get to statute 13-418, use of force in defense of residential structure or occupied vehicles. Notwithstanding any other provision of this chapter, a person is justified in threatening to use or using either non-deadly physical force or deadly physical force if they reasonably believe themselves or another person to be in imminent peril of death or serious physical injury. Well, so far they've given us nothing extra, because you're allowed to do that no matter where you are. That's just straight up self-defense. But it continues, and the person against whom the physical force was used was in the process of unlawfully or forcefully entering, or had unlawfully or forcibly entered a residential structure or occupied vehicle, or had removed or was attempting to remove another person, the kidnapping scenario. Now, 2 things to point out here. The first is, notice they don't say unlawfully and forcefully. They say unlawfully or forcefully. Now here that doesn't matter so much, because in the first part of this sentence, they already said it was justified. I mean, if you're justified under these conditions, that's just straight up self-defense. You don't really need the forcible entry anymore, because you'd be justified in using deadly force in self-defense regardless of being in premises. So this isn't giving you a lot more, but there's yet another statute. 13-419 starts with the word presumptions, and this is Arizona's legal presumption of reasonable fear statute, the equivalent to what we just read about North Carolina. It reads, a person is presumed to reasonably believe that the threat or use of physical force or deadly force is immediately necessary if the person knows or has reason to believe that the person against whom they're using the force unlawfully or forcefully entered, or has unlawfully or forcefully entered, and is present within the residential structure or occupied vehicle. Important here, or. Remember, North Carolina said and. Under North Carolina's legal presumption, you had to have both unlawful and forcible entry to remove the risk about shooting an innocent intruder. North Carolina did not want to give you the benefit of the legal presumption of reasonable fear of deadly force injury if you were facing an innocent intruder. You had to have both unlawful and forcible entry. But Arizona says, no, either one is okay. Either unlawful or forcible is enough. So a subtle difference, but an important difference. The details on this stuff matter, folks. The difference between and or here, between North Carolina and Arizona, is the difference between an acquittal or not being charged in the first place and the rest of your life in prison. So you might have heard me say in the past that use of force law is pretty much the same across the 50 states, about 80% the same. But that 20% variance can make a big difference, folks. I mean, the difference between no legal jeopardy and life in prison. So that was the legal presumption for the defender, that they had a reasonable belief that they were facing an imminent threat of deadly force harm. And then we have the legal presumption about the intruder state of mind. A person who is unlawfully or forcibly entering, or who has unlawfully or forcefully entered and is present, still present, in a residential structure or occupied vehicle is presumed to pose an imminent threat of unlawful deadly harm to any person who's in the residential structure or occupied vehicle. And then we have the exclusions under Arizona law, just like we saw in North Carolina. I believe they're exactly the same. So probably developed from the same model penal code in both states. Except this one does not have that final condition that North Carolina had, the fifth one, which was that they've already left. So they've discontinued efforts to get in. That's probably because they kind of covered that here, where they say is present in a residential. So if they're no longer present, if they've left, then you wouldn't get the benefit of this anyway. So the exclusions, let's see what else. And then we just have the jury instruction version. So right away we can see the big difference between North Carolina and Arizona. They have very similar legal presumptions of reasonable fear by the defender, reasonable fear of imminent deadly force harm when dealing with an intruder in their home. But North Carolina requires the intrusion was both unlawful and forcible. And Arizona says either one of those is fine. You don't have to have both. Now, finally, let's get to Colorado, where I currently live. Who knows for how much longer, as Colorado increasingly becomes California. But nevertheless, Colorado has a very unusual defense of premises statute. It was commonly referred to when it passed among hue and cry, blood will run in the streets. When this became law, it was commonly referred to as the Make My Day Law. It is, of course, nothing of the sort, but it's a rather unusual defense of property statute. So it's this is it, 18-1-704.5. And again, this is from our Colorado specific use of force law course. We have one of those for every state. You can learn more at the banner below, lawofselfdefense.com/state. And it reads in relevant part, notwithstanding the provisions of 18-1-704, 704 was what normally sets out deadly defensive force and self-defense. So it's saying, all right, despite what that says, you also have a privilege to use deadly physical force if you meet the conditions of this statute, 704.5. Notwithstanding the provisions of 704, any occupant of a dwelling, so it doesn't have to be an owner, anybody inside the dwelling, is justified in using any degree of physical force, including deadly physical force, against another person when that other person has made an unlawful entry into the dwelling. So first thing to note, unlawful is enough. It does not have to be a forcible entry. Unlawful alone is enough if that same person also creates in the occupant a reasonable belief that the intruder has committed a crime in the dwelling in addition to the uninvited entry, or is committing or intends to commit a crime against a person or property in addition to the uninvited entry, so something more than just the unlawful entry, and when the occupant reasonably believes that such other person, the intruder, might use any physical force, no matter how slight, against any occupant. Now, this second half of this paragraph is the remarkable portion. The first part's not that remarkable, the fact that it doesn't require both unlawful and forcible, because as we saw, Arizona doesn't either. But this Colorado statute is doing something different. North Carolina and Arizona created a legal presumption that you had a reasonable fear of imminent deadly force harm. It legally presumed these elements to be present. It didn't say they're not required. It legally presumed them to be satisfied. They're still required. They're just presumed to be satisfied. Here, Colorado is saying, you don't need them. So normally, for example, under the element of proportionality, you can't use deadly force unless you're facing a deadly force threat. And the legal presumptions don't do away with that. They simply say, we're going to presume that you reasonably perceived a deadly force threat. Colorado here is saying, the threat you're facing doesn't have to be deadly force. If that person unlawfully entered, and you have a reasonable belief that they've committed a crime or intend to commit a crime, so you're mind reading now, against property or persons inside that residence, and you reasonably believe that they might use any physical force, no matter how slight, you're justified in using deadly defensive force against them. So it's not presuming that they're presenting you with a deadly force threat. It's not requiring a deadly force threat at all. Any physical force, no matter how slight, is sufficient to satisfy the condition for using deadly defensive force against them, for taking their life, if you meet these conditions of Colorado's so-called Make My Day law. All right, folks. So those are the three states I wanted to use to illustrate highly defensible property today, because they had popped up in the news for North Carolina and Arizona. And of course, I live in Colorado, and I thought it would be an interesting juxtaposition. So with that out of the way, I will mention that now we're going to take a look at any questions and comments that have come in from the Law of Self-Defense members. This is streaming live on YouTube, Twitter, and Rumble, and to our Law of Self-Defense member dashboard. And only Law of Self-Defense members get their questions and comments answered during these live streams. It's one of the benefits of being a Law of Self-Defense member. The good news is it's dirt cheap to be a Law of Self-Defense member. You can do that by simply becoming a temporary member. Try it out for 2 weeks for merely 99 cents. If you decide you don't like it, we'll give you a 200% refund. It's a negative risk opportunity. And if you stay a member, it's still dirt cheap. It's only about 30 cents a day. It's less than $10 a month to be a Law of Self-Defense member. What are the benefits you get? About half our content, more than half, is members only. We only address questions and comments from Law of Self-Defense members. You get a transcript of every show for those of you who prefer to read rather than watch. And you get a downloadable PDF version of the transcript, so you can save that for your records to document your knowledge should you ever have to provide such documentation in court in order to get your specialized knowledge admitted before a jury, and much, much more. So I would urge you to at least try it out, lawofselfdefense.com/trial, for that 2-week, unlimited, full access, 99-cent trial membership. And if you do that, in our experience, virtually all of you stay members for the long haul, which we greatly appreciate. And you can do all this at lawofselfdefense.com/trial. All right, let me turn now to the member chat, see what we have to see here. Member Zakuza says, hoping Rackets, that would be Nick Ricada, hasn't worn off on Branca in showing up late. I don't think I was late today, folks. Maybe a couple seconds. That's it. Let's see. I was a few minutes late yesterday. Yes. One of the members references in the comment Palmetto State Armory. Folks, don't go to Palmetto State Armory unless you plan. I mean, you're going to buy guns if you go there. I have to not look at their emails because I buy way too many guns from Palmetto State Armory. In all seriousness, Folks, there is absolutely no excuse for any productive American citizen not to own an AR rifle and a 9mm service type pistol, assuming, of course, that's legal in your jurisdiction. Today, because Palmetto State Armory makes utility grade firearms, ARs, and 9mm pistols incredibly inexpensive. I think for $700 or $800 you can get the pair. It's a heck of a deal. So if you don't already have one, are you really a citizen if you don't? I don't know. I've purchased a number of firearms from Palmetto State Armory, and they've all been very functional, pragmatic guns, and very inexpensive. Let's see. Jeffrey asks, does a prosecutor have to include lesser and included charges, or is it assumed? Jeffrey, that varies a lot by jurisdiction. So a lesser included charge, an example of a murder charge, say you're charged with murder. Murder requires a intent to kill. A lesser included charge might be manslaughter, reckless manslaughter, which requires not intent to kill, but a reckless killing, which is a lower mental state. So if the prosecutor charges you with murder, but they can't prove intent, the jury may still find you guilty of manslaughter, which doesn't require intent. It has everything else of murder, but doesn't require intent. Whether or not the jury's given that lesser included charges varies by jurisdiction. Sometimes it's automatic. Sometimes the state has to request. Sometimes the defense would request, but they're not permitted to. Sometimes the defense has the absolute right to demand that the lesser included be given. And whether you want lesser included is a strategic decision in the trial. Sometimes the defense wants to compel the state to prove murder or nothing, no lesser included. But sometimes you're pretty sure that your client's going to get convicted of murder unless you give them a manslaughter option, in which case you want the lesser included provided to them. But that's a level of kind of criminal procedure detail that varies a lot from state to state. Let's see. Yeah, so for folks who don't know, I just got back from a couple-week motorcycle tour in Eastern Europe. It was wonderful. I used Edelweiss as a motorcycle touring company. I've never done an organized tour before. I virtually always travel by myself, including my previous travels in Europe. I would just rent a motorcycle and ride around by myself in Europe. But I thought I'd give Edelweiss a try. So they did provide the motorcycle. They arrange all the hotels. They arrange most of the meals, the routes. It certainly makes things much less planning intensive than arranging all that for yourself. But I was on a rental bike. The rental bike was the same bike I ride at home. It was a BMW R1250 GS Adventure. So that was very nice having the same bike. It is a huge pain to ship a motorcycle to Europe, or at least it was for me. So the last time I tried I was living in the Netherlands for 2 years, and I tried to ship my bike from the US to the Netherlands so I'd have motor transport there, and it was a nightmare. I finally gave up on the process. I don't know if it's any easier today. Let's see. Yeah, maybe I should figure out if PSA would be interested in sponsoring law of self-defense. That would be cool. Yeah, Daniel says, how would North Carolina law interpret a situation in which a burglar took advantage of an unlocked door to enter the home? That's not a forcible entry. Now, I know what you may be thinking. You may be thinking that could still qualify as breaking and entering for burglary law, for example, and it probably would. But we need to be very careful about assuming that conduct or terms of art, legal terms of art, mean the same thing in different legal contexts. So for breaking and entering law, the breaking part of that just means breaking the plane of the home. So if a door's wide open and someone steps through the open doorway, that's breaking for breaking and entering purposes. But it's not forcible entry for use of force law purposes. I mean, remember, the reason they have the forcible requirement is to remove ambiguity about an innocent intruder. So merely stepping through an open doorway doesn't do that, right? Physically breaking something does that. Same with an unlocked door. Someone sent to the wrong address and told that repairman for the dishwasher, told, hey, they're going to leave the back door unlocked. Back door is unlocked. He walks in. He's an innocent intruder. If there's even like one of those crappy screen doors, if you're my age, you know the kind I'm talking about, just a cheap wooden frame with a screen stapled to it, a little hook and eye latch, no doorknob, just right. If that's all there is, and they break the hook and eye latch to get in, which anybody could do by just pulling on the door handle, that's forcible entry. That would be sufficient. But there needs to be something, which, I always urge people, keep your damn doors locked. If someone's going to unlawfully intrude into your home, compel them to do that forcibly by breaking something that's secured. It doesn't have to be much. It could be a cheap screen door, but make them break something so that it removes the ambiguity. Now, listen, I live in a house with kids. It's almost impossible to get the kids to keep everything locked. I get it. I'm just telling you from a legal perspective, it's advantageous to you if you can manage to keep your doors locked and compel that intruder to break something. Jim asks, what if they pick the lock? Is that still force? I would say absolutely yes, because it serves the purpose of the requirement for forcible entry, right? It removes ambiguity about an innocent intruder. And they're using force on the lock, right? To overcome the lock. Let's see. But in Arizona, for example, it doesn't have to be forcible. Just unlawful is enough. Rich asks, when unlawfully or forcibly is used in the statutes, as in Arizona, have the courts limited that exclusion to return it to effectively the and condition? I haven't seen that, Rich. Could a court do that? It's possible. It would be unusual for a court to directly contradict clear, plain language in a statute. Courts are more likely to read in words than they are to simply come to an absolutely contrary conclusion. Let's see. And again, folks, these are all questions and comments from the Law Self-Defense membership and the Law Self-Defense chat, the member chat. That's the only place we address questions and comments. So if you have questions and comments for me, I don't even look at the YouTube or the Rumble comments. So you need to be a Law Self-Defense member. Try it out for 99 cents for 2 weeks, 30 cents a day. After that, less than $10 a month at lawselfdefense.com/trial. Let's see. Yeah, if nothing else, folks, I hate to talk about Palmetto again, but every once in a while they run sales on AR lowers, just the lower component. Blemished, they call them blemished. I've bought a bunch of those over the years. I've never spotted a blemish, and they all work. Of course, you have to build out the AR yourself afterwards, but the rest of it you can just mail order. Only the lower has to go through an FFL, and they're often so inexpensive. It's like I don't need another one, but it's hard to say no. Let's see. KT clicks to a one punch fight. Thanks, KT. I'll take a look at that after today's show. One Law Self-Defense member says, I have a fingerprint code card reader lock on my front door. Auto locks after 1 minute. Oh, that's a thought. All right. I think I've addressed everything. So, folks, thank you so much for spending, again, almost another hour with me. I'm so grateful. I could not possibly do this without all of your ongoing support. Thank you, thank you, thank you. Have a great weekend, everybody. Not sure if I'll do a show this weekend or not, probably. But I think Lady Emily has arranged some social functions this weekend, so it may not be possible, but I expect to have, now that I'm back from my trip. Oh, by the way, for those of you who might be interested, I am putting together a little video of the photos I took of my trip in Eastern Europe. I'll just put that up as a blog post. It's not, use of force law content, but if any of you are interested in seeing photos from my trip, I'll put them up in the blog post and send out an email about that. And if you have any questions about Edelweiss or what that tour experience was like, I'm happy to address that offline too. It was overall a very good experience. It is quite expensive. So the trade-off, so I want to say it was about 10 grand for the 2-week trip. And I don't think that includes air, because I think I used miles for the air. So that was 2 weeks throughout Eastern Europe. They provided the bike, most of the food, all the hotels, all that stuff. And they planned everything. And there's value to that too, right? Local knowledge on the ground, where to go, what to see, the good roads. That can be hard to replicate yourself, just using the internet. But to contrast that, I have one of my sisters has a place in the Umbria province of Italy, just south of Tuscany, north of Rome, kind of between Rome and Florence. Mountainous country. I plan to visit her next summer. I'll rent a motorcycle in Rome and spend a week riding around Umbria. But I'll plan all that myself. And the only expense, because I'll be staying with my sister, the only expense will be the air travel there and then the renting of the motorcycle. And I think the renting of the motorcycle for the week will be like $1,000. So much less expensive than a guided tour. But having said that, depending on your wallet and how busy you are and how difficult it would be to plan a trip. When I did this 20 years ago, I would plan these trips myself and just fly in and rent the bike and go off on my own. And that worked just fine for me. But it did take quite a lot of planning beforehand, which I don't have as much time for these days as I used to. All right, that's it. We're right up at the top of the hour. Folks, remember, if you carry a gun, carry a knife, carry pepper spray, learn BJJ, do any of that stuff so that you're hard to kill. That's why I do all those things, so that I'm hard to kill, my family is hard to kill. Then you also owe to yourself and your family to make sure you know the law, so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.